can legally be liable to face trial in the court-martial for disciplinary offences, herein called military, disciplinary or service offences, stipulated in Part 6 of the UPDF Act. 4. Whether 6 can constitutionally or legally be tried in the court-martial for civil offences not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislation. 5. Whether it is constitutional for persons subject to military law to be tried in the court-martial for offences outside the UPDF for civilians to be tried by the court-martial as principle for offences. Sections 1191H of the UPDF Act exists in the civilian each of the questions. As this will secondly and most important now section of the UPDF Act, which establishes the General Court Martial established under the law as a competent court, is constitutional. Our understanding of the above declaration is that it is duly established under the law and its existence with the Constitution. However, it must be clothed with the following: A. Members of the General Court Martial must be persons with legal qualifications. B. The members of the General be independent of the command and have tenure. C. There should be adequate time and facility in the preparation of defense by an accused person, as well as the right of an accused person to due process and an appeal in capital offences. D. The convening.
Okay. That was the
191, now respectively 177, 10X, 117, and G of the UPDF Act are unconstitutional since the conviction on court-martials to try civilians. Our understanding, the understanding of the Attorney General of this declaration and 9 by the court is that civilians cannot be tried in military. Our understanding of this declaration 7, 8, and 9 by the court is that civilians cannot be tried by military courts. I quote from the Attorney General. The minority recognizes the mandate of the Office of the Attorney General under Act 9, 3 and 4 of the Constitution of the Republic of Uganda, to wit, shall be the principal legal advisor of government, give legal advice and legal services to government on any subject. It may be recalled, Right Honorable Speaker, that in both regional constitutional petition number 45 of 2016, Honorable Michael A. Kabaziguruka versus the Attorney General in the Constitutional Court and in the Constitutional Appeal number 2, 2021, the Attorney General versus Honorable Michael K. The Attorney diligently and professionally offered legal services representation in court and lost all the arguments except the legality of existence and creation of the court-martial. However, how then does the executive and even parliament expect the same learned Attorney General to again go back to the court and Supreme Court to defend the same issues which he argued and lost? It must be very burdensome, tiresome, hopeless, and frustrating to be lawyer to the government in such scenarios. Sympathies to the learned Attorney General, Honorable Kriwa, and the team of learned friends in the chambers of the Attorney General who prosecuted the case. Can they face the same court again on the same issues already decided by court? I must reliably informed, asked to be excused from executing role of Attorney General. Then a Deputy Attorney General who was with us here, Honorable Mwesiga Rukutana, immediately he left this and he had the energy to marry even a new young wife. So it is really burdensome, Attorney General.
Honorable Odur, you're going personal. Please.
I withdraw.
She has, I mean, what's wrong with marrying a wife?
Finding. Huh? I withdraw. Finding. The minority, therefore, finds that there is no basis to provide for trial of civilians in the military court as decided by the two highest courts of Uganda, Constitution and the Supreme Court. The minority further finds that there is no political, ideological, and security narration to justify to provide for trial of non-military offences in the court-martial. Therefore, is shallow, unreasonable, and unconstitutional. Court-martials by the Supreme Court are established legally, hence there is no need to re-establish it. Court-martials as found by the Supreme Court, and this is what has to pay attention to, are already established legally, hence there is no need to establish it. The question of restructuring of the court-martial is necessary, be later pointed out, not possible through provisions of the proposed bill. Subordination of the court-martial, that's the next of dissent. The Honorable the Chief Justice, Alphonse Owendolo, in his judgment, found as quoted below. I open the quote. Additionally, as already noted, the General Marshal and other military courts are all subordinate courts. See the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1006. However, I do not agree with Mulastis of the Supreme Court's finding where he held that the General Court is subordinate but not lower than the High Court. According to the Black Laws, Brian A. Garner, 8th edition, subordinate means play it in or belonging to a lower rank, class or position, or subject to another's authority or control, assigning the ordinary English meaning to the ordinary.
Potential to create an absurdity when it comes to hearing of capital offences. If Parliament desires to grant them jurisdiction to handle capital offences, then it would need to do so in line with the Constitution. The minority observes, Madam Speaker, that Article 129 of the Constitution of the Republic of Uganda provides for the courts of judicature as stated in the judgment. Article 129.1, the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and D, which is underlined, such subordinate courts as Parliament may by law establish, including the Cadi's Court for marriage, divorce, inheritance of property, guardianship, as may be prescribed by Parliament. Article 129 of the Constitution is on the jurisdiction of the High Court and states as follows, and we can read together. 1. The High Court shall, subject to the provisions of this Constitution, have unlimited original jurisdiction on all matters, and such appellant and other jurisdictions as may be conferred on by this Constitution or other law. In light of the judgment of the Supreme Court, Madam Speaker, any court created by Parliament is inherently subordinate to the High Court. Any court created by this Parliament, whether we go ahead and create or not, is inherently, by this provision of the Constitution, subordinate. We cannot create a court equal or higher. For any court to be created with either the same or higher jurisdiction to the High Court, it has to be directly created in the Constitution under Article 129, sub-article 1, and listed either in, you can reflect, in clause 1C with the High Court, meaning at the same level, or immediately before clause 1D to exclude it from the subordination. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129, other courts other than the three courts of record, The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129D, which we are about to do, of the Constitution is equivalent to amending Article 139, Subarticle 1 of the Constitution, to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution on the High Court. I can repeat that. The minority observes further that conferring unlimited original jurisdiction on courts created under Article 129D, such as the court-martials of the Constitution, is equivalent to amending by infection Article 139(1) of the Constitution to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution on the High Court. Is it therefore allowed to amend the Constitution through an amendment of an Act of Parliament? The obvious answer is no. The Constitution can only be amended in conformity to Chapter 18, Articles 259 to 263 of the Constitution of the Republic of Uganda. The minority submits that the UPDF Amendment Bill 2025 is not a bill for an act to amend the Constitution, and therefore cannot attempt by trickery or any other means, including fraud, purport to amend Article 139 of the Constitution of the Republic of Uganda. Right Honourable Speaker, the advisory order recommendations of the Supreme Court are stated in paragraph 10 on page 199, bullet E of the judgment of the Honourable the Chief Justice Alphonse C. Owindol as follows. E, amend the Constitution, and pay attention, this is what the Chief Justice ordered or recommended. Amend the Constitution to establish superior courts within the military court system under Article 129, and clothe those courts created by amendment of the Constitution with the requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses under existing laws committed by military personnel. F, the Chief Justice advised, provide in the UPDF Act for the High Court, which is already created and in existence, to sit as a court-martial with power to try all criminal capital offenses within the High Court's jurisdiction, and those unique to the military that attract maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can therefore act as assessors. Appeals to the court-martial appeals court would follow the same format, with Court of Appeal sitting as such. Magistrates' courts would assume the jurisdictions all over other offenses of a subordinate court. G, the Chief Justice says, make provisions in the UPDF Act for trials of civilian in the military courts to be only under limited circumstances and only after the state concretely demonstrates to the court by verifiable facts and by objective and serious reasons the need and justifications for recourse to the military courts. This must only apply where, in relation to the specific class or category of persons, offenses in question, ordinary courts are not in position to undertake. This is the quote of the Chief Justice upon which this bill has been brought. The understanding of the minority on these advisory orders E to F and G above is that they are premised on the fact that all trials of both civilians and military personnel who commit non-service military offenses must be before civilian courts. In other words, the current civilian courts, Magistrates' Court, High Court, Court of Appeal, and Supreme Court are all competent by all standards required under Article 28 and 44 of the Constitution of the Republic of Uganda to try any offense in the law books of Uganda. A question was put to the learned Attorney General on whether his trust, confidence, and belief Oh, I rephrase. A question was put to the Attorney General on where his trust, confidence, and belief would lie in delivery of justice on the offenses proposed in the bill. Were those trials to take place premised on the same facts before either the civilian courts or the court-martial? So we have two sets of same offenses. Which of the two courts would the Attorney General trust? The learned Attorney General answered that both courts can and would deliver justice. The understanding of the minority on this answer is that the learned Attorney General confirmed that civilian courts in existence right now is capable of conducting any trial of criminal nature in Uganda without need to waste time and resources on the court-martial, which has unconstitutional structure. The structure, not the court-martial. The court-martial is constitutional, but its structure has unconstitutional structure, incapable of delivering a free, fair, and impartial justice to any accused person. Even, Madam Speaker, even if this answer is denied, the question to the government and the mover of the bill is the government of NRM in power for 39 years and who virtually recruited and appointed all the cadres, the investigators, the police, the prosecutors, office of the DPP, the arbitrators, the judicial officers, if we check on the record of the current structure of police, leadership, and the rest, all of them have been recruited by this government. Are they therefore justified to complain on the incompetence, the weakness in the judicial system? The question is, the NRM government in power